to ensure all Guyanese live a decent life. Barrett and Irfan did not automatically inherit this nation's wealth. They lied to you then, and they will continue to lie. It's in their nature. Do not trust this PPP. During the Christmas season, public servants remain underpaid and overworked. Many are dependent on a bonus to make the Christmas season merry, to put a smile on the faces of their children, and to have a proper meal during the holidays. But this government is an unreasonable bunch of selfish people. Our most valuable resource is our human resource. Public servants are not asking for favors. I am demanding that you pay public servants better, and all that was promised be given.
Welcome to the Deep Dive, the place where we take a stack of your sources, extract the absolute essence, and, deliver the critical knowledge directly to you. Our mission today is to take a deep dive into a legal battle in Guyana that has reached a truly extraordinary pitch. What started as a sort of straightforward international extradition request has pivoted sharply.
It really has.
It's now a major constitutional challenge. We're looking at sources detailing this recent, very high-stakes maneuver by two prominent figures, father and son, Nazar and Azruddin Mohammed.
And they are now challenging the very legislative foundation underpinning their potential extradition to the U.S.
So for you, the listener, this isn't just about, reading a legal filing. This deep dive is designed to extract the strategic calculus here.
Right. We're focusing on the precise legal mechanisms and the high-level implications of challenging a key piece of legislation, the Fugitive Offenders Amendment Act.
That's the one.
And this move is hugely significant because it immediately shifts the entire battleground. You go from arguing facts in, say, a procedural court to questioning the validity of the government's entire legal instrument in the high court. It's like arguing about the foundation of a building rather than, just the window dressing.
Okay, so let's unpack this and follow the storyline. What exactly are these individuals accused of that led to this extradition request? And critically, how does challenging the constitutionality of a law become the new aggressive front line in their legal defense? To understand the audacity of this legal move, we first have to establish the weight of the initial problem.
Exactly.
We're talking about Nazar and Azruddin Mohammed, who are identified in the sources as father and son billionaires. Their prominence, their resources, that's all central to understanding the complexity of this defense.
The problem they face originated in the United States, specifically Florida.
Yeah.
They're confronting a pretty extensive 11-count indictment filed in a U.S. federal court.
11 counts.
Yeah, that number 11, it really signals the sheer scope and complexity of the alleged scheme.
So what are we talking about specifically?
Well, our sources break down these 11 counts into, pretty serious categories of federal offenses. We're talking about mail fraud and wire fraud.
Okay, the usual suspects for financial schemes.
The engines of it, yeah. And we also have tax evasion allegations. But the real nexus point, the element that explains why this case is so complex, is the money laundering.
And the sources are very specific about the money laundering. It's directly tied to gold exports. Gold is a crucial detail here. Why is the gold element so important?
Well, if we connect this to the bigger picture, it's about fungibility and international movement. Gold is a high-value commodity.
Easy to move.
So easy to move across borders, and it's highly convertible into cash. In money laundering schemes, you often see this. They use legitimate-looking international trade, like resource exports, to obscure illicit funds. So by tying their money laundering claims directly to gold exports, the U.S. indictment is essentially saying that this legitimate-appearing business activity, the export of a national resource, was allegedly leveraged to clean or hide proceeds from fraud and tax evasion.
So the charges aren't just like filing the wrong tax forms. They involve alleged manipulation of an essential high-value international commodity.
Exactly, creating what look like legitimate international money transfers.
So understanding the severity and scope of these 11 counts, the fraud, the tax, the movement of money via gold, that's the key to understanding why they needed a highly resource-intensive, high-risk legal strategy in their defense.
It is. This is why the extradition process was initiated and why they are fighting it tooth and nail.
But that procedural fight, it was heading toward an inevitable conclusion in the magistrate's court, right?
Yes, that court is simply tasked with determining if the evidence meets the legal standard for extradition. That's it. So that necessitated a massive strategic pivot.
And here's where it gets really interesting. The decisive move was filing what's called a fixed date application, or an FDA, directly in the high court.
A huge move.
And this happened very recently, filed on December 15. The sources clearly detail that this wasn't their first choice. This was an escalation.
Let's just pause right there because we need to define the FDA for the listener. A fixed date application is a specific legal procedure. It's essentially a fast-track mechanism.
All right.
Used when the facts of a case are largely not in dispute, but the entire argument centers purely on a question of law.
So not did we do it, but is the law you're using against us even legal?
Precisely. In this instance, the question of law is constitutional validity. By filing an FDA, they are telling the High Court, we're not here to argue the evidence. We are here to argue that the mechanism you are using to extradite us is fundamentally flawed and illegal.
So they completely sidestepped the factual arguments of the 11-count indictment and went straight to the legal foundation.
Yeah.
And the target of this massive legal maneuver is the Fugitive Offenders Amendment Act.
That's the one.
What's the role of this act, and why are they challenging its constitutionality?
So this act is the domestic law that governs how Guyana handles international requests for extradition under its treaties. Historically, these acts are intended to simplify and, modernize the extradition process.
But I imagine any law that touches on fundamental liberty.
Oh, absolutely. Like the freedom from being shipped off to another country to face trial. That can be challenged on constitutional grounds, often based on, say, due process or equality provisions.
So the defense is questioning the validity of the law itself, not just how it's being applied in their case.
Yes. And if they win, the entire legal framework for extradition in Guyana is at risk of crumbling.
We know who the heavyweights are on the other side of this high court filing. Their representative is identified as Senior Counsel Roysdale Ford, and the respondent, the party forced to defend the law, is the Attorney General Il Nonlal.
And this is where the legal drama really crystallizes. Because this high court filing, this FDA, it wasn't their opening move.
Right, you mentioned it was an escalation.
Just days before they filed the FDA on December 15th, Principal Magistrate Judy Latchman had rejected their initial application. They had initially asked the magistrate to refer the constitutional issues to the High Court.
And she said no.
She refused to do it.
That refusal is the critical forcing mechanism, isn't it? The magistrate's court essentially said, I am going to stick to the procedure, and I'm not going to entertain your constitutional arguments.
Which closed the procedural door.
Exactly.
That procedural refusal forced the defense's hand. They had to immediately escalate and demonstrate a clear, deliberate move to take this foundational legal question directly to the High Court with the FDA.
So the move essentially says, if the lower court won't challenge the law, we will force the highest domestic court available to us to review it.
It is an aggressive escalation. It demands a formal, written defense from the Attorney General's office.
Okay, let's focus now on the specific outcome they are demanding from the High Court in this fixed date application, because these two demands really define this high-risk, high-reward strategy. First, the big one. They are demanding a declaration that the provisions of the Fugitive Offenders Amendment Act are, quote, unconstitutional, unlawful, and void.
That's not just fixing a leak. That's challenging the entire plumbing system.
It's a massive undertaking.
It is. If they're successful, that declaration would fundamentally invalidate the entire legal framework currently being used. It would be an enormous victory, not just for them, but potentially for anyone facing extradition under that act.
But there's a second part, right? A more immediate goal?
Yes, and equally, or perhaps even more important from a tactical standpoint, is their second request. They're asking the High Court to issue an order staying the extradition proceedings.
The ones currently underway before Magistrate Latchman.
The very same.
The word stay is the operational pivot here. It means stop, immediately. Isn't this move inherently pragmatic and, maybe a bit cynical, using constitutional law purely as a stall tactic?
That raises an important question. And yes, delay is often an intended and highly effective defense strategy, especially in complex extradition cases.
Though it's two-pronged.
It is. The legal strategy is to attempt to kill the law completely with the declaration, but simultaneously buy a whole lot of time with the stay. A successful stay order would instantly freeze the entire extradition process.
Until when?
Until the foundational legal questions about the act's constitutionality are resolved.
Which could take a long time.
Think about this. So what of the stay? What is the effect on any ongoing case when the very legal mechanism being used is suddenly under constitutional review? The delay could last months, potentially years, as the matter winds its way through the courts.
And that delay gives the defense time.
Time to gather resources. perhaps find procedural errors in the original U.S. indictment, or even just wait for political or diplomatic shifts to happen. It forces the state to allocate significant resources to defend its own legislation rather than just pursuing the case against the Mohameds.
So summarizing the procedural timeline for the listener really hammers this point home. The Mohameds went to the magistrate. She refused to refer the issue, which forced their hand.
Right.
They then went directly to the High Court via the FDA to force the issue, attempting to stall the process with a stay while they tried to declare the foundational law invalid. It's a very sophisticated and aggressive attempt to attack the state's procedural authority.
This deep dive illustrates perfectly the strategic interaction between international legal obligations, in this case, the treaty request from the U.S. for these 11 serious financial counts, and fundamental domestic constitutional protections.
And the complexity is amplified because this is not a defense based on "I didn't do it."
Not at all.
Yeah.
This is a defense based on you, the state, do not have the legal right under your own constitution to send me away.
Absolutely. For you, the listener, you now have a comprehensive understanding of this maneuver. You know the strategic names, the key legal distinction, challenging the act versus challenging the evidence, and the specific legal tool, that fixed date application.
And the critical demands. The declaration of unlawful and void, paired with the immediate tactical request for a stay.
Right. This provides you with a thorough, fact-based understanding of why this case has moved from, a routine legal notice to a constitutional crisis.
It really has.
We started by asking how someone fights an extradition by challenging the very law that governs it. And the answer is found in that aggressive, two-pronged approach. Attack the foundation for a permanent win and secure an immediate stay for a tactical delay.
It's a classic high-stakes legal gambit.
Now, for our final provocative thought for you to chew on, considering the Mohameds' request to have the High Court declare the Fugitive Offenders Amendment Act unlawful and void, what are the potential ripple effects for all future extradition cases in Guyana if the High Court were to rule against the current framework? I mean, would it require a complete legislative overhaul? Or could it invalidate other pending extradition requests that rely on that same challenged section of the Act?
That's the million-dollar question. We encourage you to continue tracking the High Court matter and the response from the Attorney General to see how this fundamental constitutional challenge plays out. The outcome here will shape the future of extradition law and potentially set a massive legal precedent for every individual facing international charges in the region.
Thank you for sharing your sources with us and allowing us to take this deep dive.